Nate Webb from the Webb Law Firm. You're here because you got arrested for a DUI, and I know what to do about it. So I want to tell you the process. So you were stopped, you were arrested. Now you're going on Google and you're looking for someone to help you out with this. I've been doing this for over 21 years. I've been in too many jurisdictions to name: federal court, superior court, municipal court, district court, all over the state of Washington. But here's the process. And by the way, I'm casual. It's Saturday today. I do wear a suit when necessary. So you're first going to be given some documents. If you are booked, you would be eventually released if you don't have any prior offenses. They might have just booked you for the night. Most of the time, they're going to let you go, but if they booked you, that was up to the trooper or sheriff or what have you. So eventually you'll be let out whether you posted bail or not. Most of the time you'll be released after you do the breath or blood draw. And so you'll be given some documents. Let's present this in the scenario of a breath test first of all. So let's say that you were arrested, you took a breath test, and then you were released or given a ride home, or Uber or a friend picked you up or whatever. The documents you were probably provided were an impound if your car was impounded, an impound notice, an inventory of that. If your car wasn't impounded, you wouldn't obviously be given that. You would likely be given the breath test document. It'll always say Washington State Patrol, even if you were arrested by a city officer or something. They use the same one that the Washington State Patrol provides, because that's who provides the drug or alcohol test machine for everyone to use, all law enforcement to use to take breath tests. So it's always going to say Washington State Patrol. That doesn't mean you were arrested by Washington State Patrol. Anyway, you'll be given that form. And then you'll also be given what is called a request for DUI hearing form. I'll put that right here. And what that is that is separate from any criminal matter that may ultimately occur. So a request for DUI hearing form is your right to ask for a hearing, a telephonic hearing with the Department of Licensing, to challenge the suspension of your license. Now, if you were just arrested and you were validly licensed to drive before the arrest, you are still right now as we speak allowed to drive. You're not automatically suspended. So whether an officer may have misinformed you and told you're automatically suspended or it's immediate or whatever, you are not. No suspension will take place for at least 30 days. Okay. So the Department of Licensing won't take any action against your license for at least 30 days from the date of the arrest. That form that I talked about, request for DUI hearing, is separate from any criminal matter. So that has to do with your driver's license only. This is what I tell people in every consultation that I give. It has only to do with your driver's license. You're looking at a 90-day license suspension, which would start exactly 30 days from the date of the arrest if you do not ask for a hearing. If you do ask for a hearing, that suspension will be put on hold, okay? And then any outcome or any suspension will be dependent upon the outcome of the telephonic hearing. If you refuse a breath test, then you're looking at a 1-year license suspension. But nevertheless, it won't happen for 30 days. And I tell every client this, and people don't sometimes remember, but you're going to be given a notice of suspension by the Department of Licensing, whether you ask for the hearing or not. So a lot of times when people ask for the hearing, they still receive the notice of suspension in the mail. Don't be alarmed. That's just their method of operation. They're going to send that out anyway. But you can disregard that if you have requested the hearing and they've received it and you have a hearing set up. Again, it'll be done by telephone, and if you have an attorney, that attorney will handle that hearing for you. A public defender will not handle that type of hearing for you. They're only there to help you with the criminal side of the matter. Okay, so you'll have to find an independent attorney to handle the Department of Licensing hearing. I always tell my clients this though. It's a tough hearing to win. Okay, the Department of Licensing hearing is very, very difficult to win because, and I have this in another video, the burden of proof in that type of hearing is by what we call a preponderance of the evidence. And I'll put that video here, okay, so you can take a look at it. But it's by a preponderance of the evidence, and that just means is it more likely than not that they can establish what they need to establish. Even in a worst case scenario, however, you are still going to be able to drive if you choose during that period of suspension in most circumstances. If you'll have to apply for what is called a restricted driver's license or ignition interlock driver's license, and that's just you submitting an application to the Department of Licensing for this license so that you can drive during the period of suspension. You will have to install an ignition interlock device on any vehicle that you drive, okay? And it only applies to you as the driver, okay? So you can't be driving your friend's car without the ignition interlock if you're suspended. You got to only drive your vehicle that has the ignition interlock in it. There are exceptions if you're driving an employer-owned vehicle for work purposes during work hours. You'd still have to have ignition interlock on your own personal vehicle, however. And you also have to have what is called SR22 insurance, which is high-risk insurance. So you have those two things. You apply for the license and they will approve it as long as there's nothing else preventing you from getting that. Okay, so that's one aspect. I always say there's kind of two tracks in a DUI in Washington State. There's the civil side, which is that request for DUI hearing form and hearing that takes place by telephone that your attorney will handle for you. You can attend that hearing if you want. Most of the time I don't have my client appear unless it's necessary for them to provide some testimony. And then you have the criminal side. The criminal side will be started by the prosecuting authority who has your case. So whether that be the county prosecuting attorney or a city. So if it's, for example, if you're arrested by King County Sheriff's Department, that's going to be very likely held in a King County District Court. If you're arrested by the city of Seattle Police Department, that will be held in the Seattle Municipal Court. If you're arrested for a felony DUI, then that would be held in the Superior Court. So if it's a local jurisdiction, a small police department, it'll be held by usually in a municipal court. And then if it's Washington State Patrol, of course, then it'll be district court. So that'll start by the prosecutor filing a charge in the court against you. And then you'll be notified via mail, old snail mail way, of what is called a summons to appear for an arraignment. And an arraignment is your first appearance in the criminal proceeding. And if you already had posted bail, for example, then that could be readdressed at the arraignment. But the arraignment is initially you to be informed of the charge. The prosecutor will file, and your attorney would have a copy of what is called a complaint, or if you're in federal court, it would be called an information. It basically the charging document to let you know that they are alleging you violated 4661502 of the Revised Code of Washington, which is the DUI statute. And so that is just to inform you. You show up and you're there with your attorney in front of the judge, and then you would be told of that. Then your attorney would speak on your behalf. You might be asked to answer whether your name and date of birth are correct, but other than that, the attorney will do all of the talking for you. And typically what is said in that type of hearing is that, Your Honor, I will acknowledge receipt of the complaint or information on behalf of my client. I'm asking the court to waive any further formal reading of it and to enter a plea of not guilty. And so the court will accept that entry of not guilty plea, and then they will ask the city or the state or whomever, the government, if they want any conditions imposed upon you, because it is a criminal offense, and so they're allowed to impose some conditions. There's a statute on what constitutes what is reasonable conditions, but in a first offense, for example, first offense DUI with no history, standard conditions would be imposed, and those are typically that you maintain law-abiding behavior, you don't drive unless you're validly licensed and insured, you're not to refuse a breath or blood test if reasonably requested by a law enforcement officer, if they had reason to believe you were driving under the influence of anything. There might be an abstinence condition depending upon what the breath test was, or the jurisdiction. Some jurisdictions just impose that as a matter of course, and they'll let you, also say, come back to court when we tell you to. Here's your new court date, and keep in touch with your attorney. Let us know if your address changes. Those are usually the typical conditions of release. Now, they'll set also what is called a pretrial hearing, which is your next hearing at that arraignment, at the end of it. The arraignment usually only takes a couple of minutes. And so it's usually done in person because there is a statute that requires you to be in person for certain types of hearings. But then they'll set it what is called a pretrial hearing, or if it's in federal court, they'll go ahead and just set it for trial. If it's in Superior Court, they'll just go ahead and set an omnibus hearing. And so it's basically just another hearing. The only one that's different is federal court. They'll just set it right to trial. Your attorney would have to file a motion if they want to challenge any evidence, a separate hearing, to set up a separate hearing. But typically, 90% of the time, I'm involved in a case where it's set for a pretrial hearing. And a pretrial hearing is where the judge just wants to know from the parties, the state or city or whoever's prosecuting it, and your attorney what is going on with the case. And typically 3 things are going to happen at that type of hearing. And so one is that you might still be engaged in negotiation or discovery exchange with the prosecutor's office. And so there might be a need to ask for a continuance of the case. And whenever we continue the case, it's usually about 30 or 45 days thereafter. Going back to the arraignment, if you're out of custody, if you're not being held in custody, you have what is called a constitutional right to a speedy trial. So this is so the state can't just file it and just say, oh, we'll get to your trial whenever we feel like it. No, you have a constitutional right to a speedy trial. And so in Washington State, it's 90 days, and most everywhere else it's 90 days if you're out of custody. They would have to bring you to trial within 90 days from the date of your arraignment, unless there is good cause reason found for a continuance or you request a continuance. So good cause reason would be like an officer is not available for trial or something like that. Integral witness isn't available or someone's sick or what have you. But whenever you ask for a continuance at a pretrial hearing, then that speedy clock starts all over again. So there's an additional 90 days. And so there can be a number of pretrial hearings because sometimes, especially in Seattle, the municipal court takes a long time to get videos from the Seattle Police Department. So the city attorney requests the videos from the police department, and then they lollygag around it. It takes a while to get videos, although, it's kind of surprising to me how the media can get videos so quickly, but we can't, nevertheless. So there could be a continuance or 2 or 3 or 4 of the pretrial. But eventually push will come to shove and the court will want the case to move along, rightfully so. And so one of a couple other things can happen. As I mentioned, there's 3 things that can happen at a pretrial hearing. A continuance, or we can set it for trial, or we have reached a resolution of the case. And we can either enter that disposition or that plea bargain, if you will, at that hearing, depending upon the jurisdiction, or they might set it for a separate, what we call disposition hearing, or a hearing to enter that plea. In federal court, they'll go ahead and do it on the trial date. In district court, usually we set it for a separate disposition hearing. But again, it depends on the municipality or the jurisdiction as to whether they'll do it right then and there. If we're not able to reach a resolution of the case, your attorney has a couple options, and you're obviously involved in this too, as to whether or not to set the case for trial. And prior to trial, however, you have the opportunity to challenge evidence in the case through what is called a suppression hearing, or what we call a 3-6 hearing. It's criminal rule 3.6, and that's to make a motion to suppress evidence in the case. So this is where a case might be dismissed if evidence isn't established. And so in this type of hearing, however, it's not beyond a reasonable doubt as it would be in front of a jury. It's just a judge making a determination as to the sufficiency of the evidence. And so some things that might be argued in that type of hearing would involve that the stop wasn't reasonably justified, or there wasn't reasonable suspicion to stop the individual. And so if that were the case, like I've done this over 20 years, and so I've had many cases where the officer was found not to have a reasonable basis to have stopped my client, and then the judge would rule that that was insufficient, and therefore that then would result in the rest of the evidence being suppressed, and ultimately the case couldn't proceed because they wouldn't have any evidence to further go on. And so that's called the exclusionary rule, or fruit of the poisonous tree. So anything ill-gotten or gained as a result of a bad stop is not admissible, and so that it would be excluded. So that would be, for example, again, if a trooper saying that you were weaving in and out of your lane, and the video doesn't establish that, the officer, testifies to it under oath, and the judge looks at the video and doesn't agree, then it could be dismissed on that basis, or a number of other reasons. The other would be whether or not there's probable cause. This is another thing that can be determined by the judge at a suppression hearing. Was there probable cause to arrest you? And so probable cause is not a high burden, okay? But it's based usually upon the observations and experience of the officer. And so in a probable cause hearing, we would have testimony, likely video from the trooper or officer or whoever, from their body cam or dash cam or both, and they would try to establish why they made that decision to arrest you. And usually that's what they call a totality of the circumstances, is what I hear all the time from officers. It was based on the totality of the circumstances. So that means that not only the driving led me to stop the person and believe they were driving impaired, but also bloodshot watery eyes, slurred speech, flushed face, poor balance. And then if you did field sobriety tests, which I do not recommend you do, you can watch my other videos on that. Don't do field sobriety tests. But if you did do those, inevitably they're going to find that there were clues on those field sobriety tests. And so all that together, the totality of the circumstances, would lead the officer to have probable cause. And so the judge would make that determination. Most of the time, if you did a field sobriety test, the judge is going to find there was probable cause. Again, it's not a high burden at this type of suppression hearing. It's not the same as beyond a reasonable doubt. Okay, so very few cases are dismissed at this juncture of the procedures. So another thing might be argued there would be admissibility of the breath or blood test. Again, it's a suppression hearing, so those arguments could be made as well. Again, kind of a lower burden there. It's up to the judge to make that determination. If everything is found to be copacetic, so to speak, then the case can still proceed on to trial. There's still a possibility of working out a resolution with the prosecuting authority prior to trial, but typically it's the position of the prosecutor or their supervisor that if you've proceeded to a suppression hearing, any deal they previously made would be withdrawn because they had to go through this process. That's just typical of how prosecutors work. It's not negative on them. That's just that we all know that's the way it works. And so then you can proceed to trial, and I can get into a whole nother video on how a trial would work because I've already gone kind of lengthy here. But we can proceed on to a jury trial, and obviously there are 3 possible outcomes at a jury trial. There's either a guilty verdict, a not guilty, or acquittal, or there can be a hung jury or what we call a mistrial, which would mean that the case could be refiled and retried again. And so if you found yourself here wanting to know what to expect with the DUI, give me a call. I'll help you through it. I've done this thousands upon thousands of times all across Washington State. And, feel free to reach out with any questions you have. All right.